Okay, we are live now.
Should we start?
Good afternoon to everyone of you present today. It is my great pleasure for me to introduce our speaker today, who is giving to talk to us about the intellectual property rights. Dr. Monika Shukla is an Assistant Vice President, Special Projects and Shadow Consultant Private Limited. She is Ph.D. in Physics from Integral University and has over 10 years of progressive experience within the intellectual property rights with the specific experience throughout the full spectrum of various technology of the institute and the companies. It is an honor and a privilege for us to ma'am, privilege to us, ma'am, to have you with us today. Today we have joined here for the lecture on intellectual property right, and I'm sure we will be enriched by this lecture. And once again, I welcome all of you for this lecture. Please, ma'am.
Thank you, Dr. Anuradha. Ritika, can you please?
Yes, ma'am, I'm sharing the video.
Ritika, I think video has stopped.
Sorry?
Video has stopped coming on the screen.
It has stopped. I'll share again then. Is it visible now?
Yes, ma'am. Now it is visible.
Okay.
Thank you, Ritika. So now first, I will start with the question first. What is intellectual property? बौद्धिक संपदा अधिकार क्या है? तो जैसे हम घर खरीदने चाहते हैं तो हम क्या करते हैं, घर जब हम खरीदते हैं तो हम उसका रजिस्ट्रेशन कराते हैं, एंड जब हम रजिस्ट्रेशन कराते हैं तो हमें उस जो है जब हम रजिस्ट्री कराते हैं तो घर हमें उस जब जो हमने घर खरीदा है जिसके लिए हमने पे किया है, हमको उसके जस्ट काइंड ऑफ प्रूफ हमें रजिस्ट्री के पेपर मिलते हैं, जिसको हम कहीं भी शो करके ये प्रूफ कर सकते हैं कि ये घर हमारा है, हमने इसको खरीदा है और ये हमें बिलोंग करता है। सिमिलरली मान लीजिए आप कार खरीदने गए, है ना, आपको कार के भी पेपर्स मिलते हैं, भाई आप जाके खड़े होकर किसी भी कार को नहीं कह सकते वो आपकी कार है। अगर आप गए, आप इफ यू वांट टू प्रूव दैट पर्टिकुलर कार belongs to you, then you need to show the papers related to that. Similarly, whatever we are creating using our mind, using our intellect, जो कुछ भी हम अपनी बौद्धिक संपदा को इस्तेमाल करके बनाने जा रहे हैं या क्रिएट करने जा रहे हैं, जो इनोवेशन हम करने जा रहे हैं, आइडियली वो हमको बिलोंग करता है, बट द क्वेश्चन इज हाउ यू आर गोइंग टू प्रूव इट। तो सिमिलरली जो इंटेलेक्चुअल प्रॉपर्टी राइट है वो हमें एक तरह से एक प्रूफ देता है कि जो भी हमने इनोवेशन की है, जो हमने रिसर्च की है, वो हमारी है और हमको बिलोंग करती है, जिससे कि कोई दूसरा बिना हमारी परमिशन के ना उसको यूज़ कर सके, ना उसको बना सके और ना ही उसको सेल कर सके। So intellectual property is a product of your mind and it is belong to you. Nobody should use, make or sell that property just like your house and your car without your permission. So intellectual property is a right which provides you to claim the right on your innovation or on your research. It is a legal right given by a government of our country. Like अगर हम इंडिया में हैं तो हमें भारत सरकार ये राइट देती है to claim that this particular innovation belongs to me. ओके, जब आप पैटेंट, आई विल लेटर ऑन माई लेटर स्लाइड आई विल टेल यू कि कितने तरह की इंटेलेक्चुअल प्रॉपर्टी होती है। तो जब आप जो रिसर्च करते हो, जब आप पैटेंट फाइल करते हो, आपको उन या जिस भी आप पर्टिकुलर ब्रांच के अंदर आपने अपना इंटेलेक्चुअल प्रॉपर्टी राइट रजिस्टर किया है, आपको गवर्नमेंट ऑफ इंडिया से एक सर्टिफिकेट मिलता है जो ये प्रूव करता है कि ये पर्टिकुलर इन्वेंशन आपका है और कोई दूसरा इस इन्वेंशन को बिना आपसे पूछे ना बना सकता है, ना बेच सकता है, ना सेल कर सकता है। इट इज़ अ लीगल राइट granted by the government of our country. If you are Indian, it is the government of India who are going to give the right to you, so that nobody can else create, make, use and sell the particular invention without your permission. सो इंटेलेक्चुअल प्रॉपर्टी राइट में कई वर्टिकल्स होते हैं, लाइक पैटेंट्स, कॉपीराइट, ट्रेडमार्क, इंडस्ट्रियल डिज़ाइन, जिनमें हम लेटर ऑन टच अपॉन करेंगे. सो आई विल गिव यू टू एग्जांपल. First, we will see some good and bad, positive and negative case study related to intellectual property. So, Coke can opener सबने देखा होगा. So, everybody must have drink the cold drink in the can nowadays. तो अर्लियर क्या होता था, जो कोका कोला था वो कांच की बॉटल्स में सेल होता था, और कांच की बॉटल्स में सबसे बड़ी प्रॉब्लम ये थी कि जब आप उस बॉटल को ओपन करते थे तो जो उसकी एजेस थी वो सेरिएटेड हो जाती थी. कोका कोला का टारगेट मार्केट क्या था? चिल्ड्रंस, टीनेजर्स. सो द रिस्क वाज कि सेरिएटेड एजेस के साथ अगर बच्चे या टीनेजर उसको पिएंगे तो दे कैन हर्ट देमसेल्फ. So this was a bigger challenge for Coca-Cola. So Coca-Cola was trying to do a lot of innovation to create some kind of just to find a solution to that, but they were not. Do you sincerely think Coca-Cola invented the Coke can? No, it was not Coca-Cola. There was a person who invented the opening mechanism of the can. Have you seen the opening mechanism? क्या होता है उसमें? एक सर्कुलर रिंग होती है, एक ट्रायंगल सा पॉइंटेड एरो होता है और एक सिरेटेड, थोड़ा सा सिरेटेड एजेस बनी होती है, जो वो पोर्शन होता है एक थोड़ा सा उसको अलग कर दिया जाता है और जैसे ही आप रिंग को ऊपर उठाते हो वो ट्रायंगल आपका डाउन जाता है और कैन ओपन हो जाता है. The person patented this particular mechanism of opening the can. And can you guess कि Coca-Cola से को उसने अपने patent, he just filed the patent and did nothing. He didn't make the thing. He filed a patent, he took right on his innovation, and then he licensed that patent to the Coca-Cola. And he took just 1 cent per can. Now imagine how much money he must have been making. Similarly, the second example is it is an Indian case study. There is a gas and petroleum industry, very big, renowned name in India. I will not name that company. So their main business was the petroleum and gas. So छोटी छोटी इनोवेशन तो R&D सेंटर होता है कंपनीज में, तो मेन स्ट्रीम के अलावा भी कुछ ऐसी एडिशनल इन्वेंशंस होती हैं जो होती रहती हैं. तो कंपनी दिस कंपनी इज अ वेरी बिग साइज कंपनी. सो जो छोटी छोटी इन्वेंशंस थी उनके साइंटिस्ट ने दे हैव डेवलप्ड द सेफ्टी कैप, जिसमें आप जब क्या होता है जब स्ट्रिंग, आजकल जो सिलेंडर में स्ट्रिंग वाले कैप होते हैं, जब आप स्ट्रिंग को पुल करते हैं तो कैप पॉपअप कर जाता है, लेकिन कई बार क्या होता है स्ट्रिंग टूट जाती है, देन इट बिकम्स वेरी डिफिकल्ट हाउ टू ओपन इट. सो दे डेवलप्ड मैकेनिकल सिस्टम जिसमें आप पुश करिए और वो जो लीवर अपने आप पीछे हटता है और कैप ओपन हो जाता है. एंड दे थॉट ओह this is a very little innovation. They didn't even bother to look what kind of usage it has. They said oh it's a secondary innovation for them. So उन्होंने उसको चिंता ही नहीं की कि उसको उनको बोला भी गया कि इस बड़ी अच्छी इनोवेशन है भाई, इसको सिक्योर कर लीजिए, इस पे पैटेंट फाइल कर दीजिए, अपने राइट्स ले लीजिए. They said oh we are too big to bother about this little invention. And later on what happened, the whole neighboring market of India is flooded with that technology. It was such a good technology. अभी जब पेट्रोलियम इंडस्ट्री में डाउनटर्न आया, दे थॉट कि चलो रेवेन्यू का सेकेंडरी सोर्स ऑफ जनरेशन ढूंढते हैं. Then they thought कि let us pick up the secondary innovation which we have done, and then we used to let us monetize those. But the thing was gone because the market was flooded with this, so they cannot even claim that this invention is there. So this is the saddest part of India. So there are various streams under which we can protect our intellectual property. There is a provision of patent, there is a provision of copyright, there is a provision of trademark, there is a provision of industrial design. There are some more vertical also, but these four will impact the university and the technical research. So let us see what patent is all about. Patent is a legal right granted by the government of a country. In India, it is government of India who is granting you the right to prevent the other from making, using or selling your invention. So nobody can even make, use or sell that innovation which is granted to you. But for getting a patent, there are certain conditions. If you are doing good research, if you are doing something new, really innovative, you need to file a patent. There are certain conditions for patentability. The three conditions which holds for patentability are novelty, non-obvious, and the invention should be industrially applicable. I assume third part is you all will understand automatically. Okay, I'll explain the first part. First, I'll give you another case study. तो आप लोगों ने पार्किंग जो पार्किंग होता है वहाँ पे जो पेमेंट करने की मशीन देखी होगी. तो अर्लियर क्या था कि जो पार्किंग मशीन फी मशीन लगी होती थी, सो वो पेमेंट लेती थी केवल क्रेडिट कार्ड से. तो जब उसमें कभी कभी क्या होता था, कॉइन अगर यूज करने होते तो देन देयर वाज अ प्रॉब्लम. सो देयर वाज अ कंपनी कॉल्ड मॉड्यूल इलेक्ट्रॉनिक एबी. इन्होंने क्या किया, एक ऐसी पार्किंग मशीन बनाई जो कि क्रेडिट कार्ड से भी पेमेंट ले लेती थी एज वेल एज फाइन से भी. सो दे थॉट इट इज अ वेरी गुड इनोवेशन. सो व्हाट दे डिड, इन्होंने कहा चलो इसका ट्रायल करते हैं. दे डिड अ ट्रायल फॉर द मशीन और उन्होंने उसको अपनी पार्किंग में लगाया और उसका 6 मंथ तक ट्रायल किया एंड दे गॉट वेरी गुड रिजल्ट. After 6 months, when they realized, oh, this is a great invention and this is successful, so they thought, let us file a patent on that. They went to patent office और उन्होंने patent file कर दिया. In the meantime, इनके opponent थे AB Kale Industry. उन्होंने क्या किया, they were tracking their activity and when they found when they heard and when they found that they have installed that they have installed that machine in their parking, what they did, they went there, they parked their car there and they just pull out, they did the payment and उन्होंने क्या किया, उसकी रिसीट निकाल ली और रिसीट निकाल के वो आराम से बैठ गए. अच्छा, मॉड्यूल इलेक्ट्रॉनिक्स ने अपना पैटेंट फाइल किया एंड दे वेटेड. जब इसका एग्जामिनेशन आया, एग्जामिनेशन में जब पैटेंट प्री ग्रांट अपोजिशन के लिए ओपन हुआ, एबी केल इंडस्ट्री ने उस पैटेंट को अपोज किया. ऑन विच ग्राउंड? ऑन द ग्राउंड दैट दिस, जब इन्होंने पैटेंट फाइल किया उससे पहले ये मशीन नोन थी, दैट नॉवेल्टी इज नॉट देयर. The module electronics said, oh, so what? We have, it's our machine and we have applied it in our parking. So the judge said, no question, novelty has gone. Even if you are disclosing by yourself, then also novelty has gone. This is very important for the university, because in university you are doing a lot of publications. So if you are really developing something good, which is new, it is a good invention, you should file a patent for them first and then go for publication. The second condition for patentability is it should be not obvious. When I say it should be not obvious, what does I mean? I mean there must be some inventive step. Okay, I'll explain this point also with an example. Let us take an umbrella. Okay, and umbrella लेते हैं और उसमें कुछ bulb hang कर देते हैं. Do you sincerely think it is it is a patentable invention? No, it is not. Because दो चीजों, umbrella is already existing, bulbs are also existing. आपने दो चीजों को combine किया and you think it is an invention? No, it is not. Because there is no inventive step. दो चीजें already exist करी थी, उनको आपने join कर दिया. So how can you make this invention a patentable invention? To make this invention a patentable invention, we can do a lot of things. Like if we add a solar panel on that, so that it can, or a kind of sensor in that, so that it can sense the light of ambience and then accordingly switch on the bulbs as per the need. Then you have added an inventive step in that, and that invention can be patented. So if you're thinking to go for patenting, just do a quick search that your invention should be novel. When I say novel, it should be worldwide, not even disclosed by yourself. So when you are in university, it becomes very, very important. Then if you are doing good research, if you are going to do something new, really, you before publication you should check it for whether it is patentable or not. To check, to ascertain the novelty, you need to check different kind of databases to see whether some similar kind of thing exists or not. And then you see whether there is any inventive step in that. It should not be obvious to the person who is skilled in the art. And the third, of course, it should be industrially applicable. So now the second thing is, yeah. Now here comes TM. आप ये slide देख रहे हैं? इसमें टीएम के पीछे आपको कुछ मार्क्स दिखाई दे रहे हैं. What are these? These are trademarks. जैसे हमने टाटा देखा तो हमें दिमाग में हाँ क्वालिटी ठीक ही होगी. It will not be so bad. It will be good quality. Sony, oh, the picture quality will be good. So, trademark is a name associated with the brands. It gives a recognition to the quality of the product. So whatever name you think for if you are going to develop a product or creating something, if you are thinking to give some name, that brand name it can be protected under trademark. Or you are creating any jingle or taglines so those are protected under there is a provision of trademark, so that those can be protected under trademark. Now next is copyright. This is very, very important vertical for the university perspective. When I say copyright, what does it mean? Right to copy? No, it is not. It is a negative right. That says you must not copy the content as it is. So in India, all the software or the literary work is protected under Copyright Act. आप लोग publications करते होंगे, उसमें भी copyright is very, very important. All the lectures you are giving, all the presentations you are making, those are protected under copyright. And it is it actually if it is a criminal offense if you copy somebody else's material and going to paste it and then going to present it somewhere, it is a criminal offense. So be very, very careful when you are going to copy or creating contents upon somewhere. So I will give some in India. Software per se is also protected under copyright. If you're creating some software, writing some algorithm, those comes under Copyright Act, and there is a provision to protect them into under copyright. Again, I will touch base on patent and explain a little bit how these 3-4 things actually impact a product. Like I said, if you are doing a research and creating something new product, okay, I'll give you an example. जैसे मैंने कोई research किया and I have created a mobile. Okay, I have created some kind of technology जिसमें वो जो है आपके I'm giving just an example. Like मोबाइल में कैमरा सेट पे होता है, ठीक है, बट आई हैव क्रिएटेड समथिंग जो कि क्या करेगा, some software kind of thing which will recognize the eye motion, and then accordingly if you are ready for to face the camera only, then it will click automatically. मान लीजिए मैंने कुछ ऐसा बना दिया, ठीक है. आप सच्ची सोचते मुझे पूरे मोबाइल के लिए पैटेंट मिलेगा? मोबाइल तो ऑलरेडी एग्जिस्ट कर रहा था. The feature which I have developed new, I can claim a patent on that. So and this technology will get covered under patent. ओके ठीक है, हमने मोबाइल बना लिया, हमने उसको अच्छा सा नाम दे दिया, कुछ भी नाम जैसे दे दिया, मान लीजिए हमने दे दिया समथिंग सम ट्रेडमार्क, और या हमने उसको रिप्रेजेंट करने के लिए कुछ अच्छा सा लोगो सोचा, दैट लोगो दैट नेम, और उसकी मार्केट, अगर उसको मार्केट करने के लिए आपने अच्छी सी टैगलाइन सोची, दैट टैगलाइन कम्स अंडर ट्रेडमार्क वर्टिकल. ओके, अब इसके बाद हमने क्या किया, प्रोडक्ट हमने बना लिया, हमने ट्रेडमार्क कर लिया, नाम अच्छा से सोच लिया, टेक्नोलॉजी बना ली, एंड अब ये हुआ कि चलो इसको मार्केट करते हैं. जब इसको मार्केट करने के लिए चाहेंगे तो आप कुछ इसके लीफलेट्स तैयार करेंगे, कुछ रिटन मटेरियल तैयार करेंगे. दैट रिटन मटेरियल कम्स अंडर कॉपीराइट प्रोविजन. ओके, एंड जब आप प्रोडक्ट डेवलप करेंगे, आप प्रोडक्ट की जो डिजाइनिंग करेंगे, जिसकी ये किस तरह का प्रोडक्ट मेरा बाहर से दिखेगा, that the outlook of the product is covered under industrial design. So mainly these 4 verticals of intellectual property are going to impact when you're doing a technical research. And for in university perspective, if you are going to create some project report, if you are doing some presentations, if you are preparing even lecture notes, that should also be protected by Copyright Act, so that nobody can else use that content without your permission. With that, I'll say, if you have any query, if you people want to ask something, you can pose your questions. If anybody wants to ask anything, they can post their question. And rather than, if somebody asks want to ask any question, they can pose it.
Ma'am, I have one question.
Yes.
Is there any cost for filing a patent in India?
Yeah, ma'am. There is cost involved. There is government fees. It's given in the patent office website. So there are government fees involved in each step, because there are multiple steps when you file patent. It is a government process, and there are certain steps defined in that. So each step has its own cost, and the cost is given in the official website of patent office.
Cost is involved initially or after the acceptance of
नहीं, जब आप फाइल करते हैं ना, तब आपको गवर्नमेंट फीस पे करनी पड़ती है.
Okay, whether it is accepted or not, just you have to pay initially.
हाँ जी.
And what is the procedure? There are some certain websites, I think, or what kind of procedure for filing? Means there is some companies through which we can file the patent.
Yes, ma'am. We also provide help to various universities, various IITs. So again, जैसे मैंने बोला ना, आपको 3 क्राइटेरिया जो मैंने अभी एक्सप्लेन किए, वो 3 क्राइटेरिया मीट करने होते हैं. That you need to check. And if you are okay, if you think that these 3 criteria are going to meet, then you can, because if you just say, like I said, if you come through us, what we do is सबसे पहले हम first 2 criteria check करते हैं, वो exist करते हैं कि नहीं करते हैं. अगर first 2 criteria नहीं meet करते हैं, then we will not advise to follow it further.
Okay.
क्योंकि नॉवेल्टी जो होती है ना मैम, वो वर्ल्ड वाइड चेक करनी होती है. आप भले इंडिया में फाइल करने जा रहे हैं, बट यू नीड टू चेक कि ऑल ओवर वर्ल्ड कहीं किसी ने सेम इन्वेंशन ना किया. अदरवाइज आपने अगर फाइल भी कर दिया, मान लीजिए एग्जामिनेशन भी होता है पैटेंट का, तो वो पैटेंट ऑफिस चेक करेगा. अगर उसमें निकल आया तो आपके सारी फीस भी बेकार हो जाएगी, पैटेंट रिफ्यूज हो जाएगा. इसलिए बेटर है कि आप पहले उसको चेक करके फाइल करें, जिससे पैटेंट के ग्रांट होने के चांसेस हाई. Sorry, it is mandatory for an article to be gone through industrial process. No, for registered design, it is not the criteria. The criteria of industrially applicable is for patent. If you are going to register a design, the criteria is not. Novelty should be there for registered design. The design should be new. I think the question somebody has posed the question. I think you are listening. You are being able to listen me. That the industrially the patent, if you are going to file a patent, it should be industrially applicable. For a design, there are certain different rules. Like it should be novel. There should be novelty in design, and industrially applicable. There comes a different rule. Yeah, patents are very important for society and business, because when they actually, the person who is doing research, मान लीजिए जो भी research कर रहा है, he also want to monetize his innovation, because आपने कोई चीज सालों की मेहनत के बाद बनाई और वो पब्लिक में ऐसे ही चली गई, जिससे आपको कोई भी मॉनेटरी बेनिफिट नहीं मिला, then you will also feel bad. So patents are useful for society, and at times what happens if like I said, if you have seen the example in the present scenario, that they are saying that important patent should become into public, like जैसे अभी कोविड में हुआ ना, लोग मोनेटाइज करने की कोशिश कर रहे थे, so they are going to create, all the countries are going to create a pool kind of thing जिसमें जो important patent है कोविड related वो उसमें वो सबके एक्सेस के लिए होंगे. सो इट इज़ वेरी इंपॉर्टेंट बिकॉज जिसने बनाया है, कहीं मान लीजिए मैंने कोई चीज़ बनाई और मैं उसको मोनेटाइज करके बैठे रहूँ और वो सोसाइटी के बेनिफिट के लिए हो, वो सोसाइटी में आना जरूरी हो, तो हम वो आएगी कैसे? सो पैटेंट वर्क्स ऑन बोथ वे because there is a provision of license. If somebody is creating something which is of very use for society and he is not going to give that research to society, then there is a provision of licensing, compulsory licensing, so that society can get the benefit out of that. So it is useful for society as well as for the business. It gives a cutting edge. भाई business में अगर आपने जो करा सेम चीज दूसरा करेगा तो आपके पास एडवांटेज नहीं रह जाएगा ना. What cannot be patented? There is an article section 3 in Patent Act. There are certain things which cannot be patented. There is complete article on that. Sorry, complete section in Patent Act. Like frivolous, I will give some example. Like जैसे frivolous invention होती है वो patentable नहीं हो सकती हैं, है ना. तो और या जैसे आपने लाइक अ सेड, इफ यू आर गोइंग टू, जैसे मैंने अभी एग्जांपल दिया था, मैंने बल्ब ले लिया, अम्ब्रेला ले लिया, दो चीज़ों को जोड़ दिया, वो पैटेंट नहीं हुआ ना. तो देयर आर सर्टेन क्राइटेरिया विच कैनॉट बी पैटेंटेड. दोज आर गिवन इन सेक्शन 3 ऑफ इंडियन पैटेंट एक्ट. Because it's a complete section.
Well, thank you, ma'am. Now I would like to invite Dr. Seema Srivastava, ma'am, to give a vote of thanks.
A very graceful and warm good afternoon to our guest, Dr. Monika Shukla, and all others present here. It is my privilege to propose a vote of thanks on this occasion. I, Dr. Seema Srivastava, on behalf of Physics Department, extend my most sincere thanks to the Almighty God for making today's event a great success. I extend a really hearty vote of thanks to Dr. Monika Shukla, who has spared time from her busy schedule. I am immensely thankful to Honorable Chancellor Professor Syed Wasim Akhtar sir, Pro Chancellor sir, Professor Syed Nadeem Akhtar, Honorable Vice Chancellor sir, Dr. Javed sir, Professor Akil Ahmed, the Pro Vice Chancellor of this university, and Dean Sciences Professor Abdul Rahman Khan for their enormous cooperation and encouragement in organizing such type of events in the university. I am very fortunate enough in having a very active and dedicated staff of my physics department. I am very much thankful to all of them, especially Dr. Harun, for their efforts in organizing this event. Last but not least, a big thank you to each one of you who made this lecture a successful event. Thank you very much.
Thank you, ma'am. Thank you.
Okay.
Thank you, ma'am.
Most welcome.